everyone, I'm Julia Walker, a North Carolina estate planning attorney, here to help you understand why it is important to plan for your life and legacy. Today, we are talking about wills. A will is a document that sets out the disposition of your assets after your death. You say who gets what and who is in charge of making that happen. Someone named in a will to receive your assets is called a beneficiary, and the person in charge of making that happen is called an executor, an executrix, or a personal representative. After you pass, your will has to be filed with the probate court to be reviewed and approved by the clerk of court before your executor can act on your behalf to gather your assets, pay your creditors, and then distribute the assets to your beneficiaries. So a will does not avoid probate. Probate is a court process where a judge says who is in charge of an estate to make sure assets go to the individuals legally entitled to them. Assets titled in your individual name, jointly without right of survivorship, and assets without beneficiary designations pass through probate. A will is public record, meaning it is open to creditor claims and is more prone to contests due to the public nature and also legal notice requirements. Who you're leaving your assets to and the amounts that go to them becomes public record. This can result in beneficiaries being subject to scammers who search court records to find targets who have an inheritance on the way. The provisions of the will only come into effect upon death, and unlike the movies, North Carolina law does not require a meeting for the formal reading of the will. This touches back to the will being filed because any person can view the will as it is a public record. Going through probate can be time-consuming depending on the complexity of the situation. It could take a year or more for your assets to be distributed to your beneficiaries. There's just going to be delays, and it will just take a while to go through that court process. Also, probate will have to occur in every state and county you own real estate, which results in double court proceedings, double court filing fees, and double attorneys and attorney's fees if an attorney gets involved or you hire one. It's important to note that wills do not apply to assets where you have a surviving joint owner or where you have a living beneficiary designated. So for example, on retirement accounts and life insurance, if you have a spouse named and then your children, that asset will be payable directly to the living beneficiary who is named and passed outside of the will. Because of this, a review of all of your assets must be part of the estate planning conversation. You need to make sure that your plan is in sync with everything owned jointly and everything that has a beneficiary named. This will ensure your estate plan as a whole will work together accordingly to your wishes. You need to be cautious with beneficiary designations, and we'll dive into why in another video, but this is going to be it for today. I hope you liked this video and found it helpful. Please share with anyone you think needs to hear it. Again, I'm Julia Walker, a North Carolina estate planning attorney, here to help you understand why it is important to plan for your life and legacy. Have a great day.